Hello, my name's Dave Johnson. I'm an attorney at Virginia Beach Law Group here in southeastern Virginia, and we're continuing our discussion on the nuances of estate planning and estate administration in Virginia. As I reminded you in the last video, I'm a Virginia lawyer talking about how we do things in Virginia. So I'm happy to have you and appreciate your curiosity if you're watching from someplace not Virginia. But please don't think that once you've watched this that you should run off and give somebody a lesson about who someone's legal heirs are. This is the second in a series, and I promised last time to unpack who a person's legal heirs are. Heirs, if someone passes away and does not leave a will behind. We have a statute, Virginia law, that sets out the pecking order of who inherits from you if you pass away and don't leave a will. It's Code of Virginia 64.2-200. And so when somebody passes away and doesn't leave a will, the inquiry goes like this. First of all, did the deceased person leave a spouse? If yes, then a spouse inherits everything. Now, there's an exception to that, and the exception is if the deceased person is survived by a spouse and by children who are not the children of the surviving spouse. Then the children inherit 2/3, and the spouse inherits 1/3. Now, I'll tell you what, that usually doesn't make for happy bedfellows, and we've got that case right now. Our clients are 2 children who have inherited 2/3 of their mother's house and have a stepfather who's not the least bit happy that the 2/3 of the house he's living in are owned by his stepchildren. So we'll never know if the deceased mom, the wife, wanted that to happen or not, but that's what did happen, and here we are with an unhappy situation. She should have had a will. Let's unpack the term spouse a little bit. Spouse in Virginia means lawful wedded spouse. That's important and interesting. I'm doing this in spring 2024. Our governor has just signed into law a statute that says that any 2 people, 2 humans, can marry in Virginia. So it doesn't matter if you're Mr. and Mrs. or Mr. and Mr. or Mrs. and Mrs., 2 people can marry. I'm telling you that to emphasize we don't do triplets. We don't do thruples or whatever threesomes are called. 2. But to be married, you have to have had a solemnization and a marriage certificate completed by the person who officiated at your wedding on file at the courthouse of the county where it happened. I've had a number of consultations where somebody desperately trying to cling to hope that by living together for a long time and owning property together for a long time in Virginia somehow can ripen into common law marriage. Not in Virginia. This state does not recognize common law marriage, and I don't care how long you've lived together. I've had consults where somebody's wringing their hands and, oh, Mr. Johnson, you don't understand. We lived together for 30 years. That's the same as being not married in Virginia. Now, there's an exception to the rule that Virginia does not honor common law marriage. Virginia will honor common law marriage if your marriage arose in a state where it is recognized. There are not many, but there are a handful of states in the U.S. where common law marriage can arise. So if you think that when you lived there, you met the criteria in that state to be considered married, then your common law marriage will be honored here in Virginia. But I am urging you, if I'm talking to you right now, to document whatever it does, whatever it takes, to have some kind of proof that you did create a common law marriage in the state where it was recognized. I'm going to tell you a little story because I know that one of the states that recognizes common law marriage is Montana, which is where I happen to be from. Well, friends of mine created a common law marriage, but I know that, number one, the quality of common law marriage counts on them having held themselves out actively to the public as husband and wife and have done things like filed income tax returns with the state, calling themselves spouses. They owned property together, they had kids together, and then once they decided to go ahead and make it official in their own minds, even though they were living as husband and wife, in Montana, what you do is and it's a form you can download from the state of Montana website, but there you can file an affidavit of common law marriage, and then once the document's filled out, you file it at your county, what in the county courthouse is called there, the clerk and recorder's office. and you have a record that you have created a common law marriage and that you have a spouse. So if you think you can justify the existence of a common law marriage, I'm urging you, if you're living in Virginia now, do whatever it takes to document from the state where you think your common law marriage arose. I'll tell you this, I don't think, now that I've told you that Montana recognizes common law marriage, I don't think it would meet the criteria. If you were to run off to Montana, it's March right now. If you were to run off for a late in the season ski week at Big Sky or someplace and check into the motel as Mr. and Mrs. and then come home and think that you had created a common law marriage, I don't think that would withstand scrutiny. Word to the wise. So anyway, if you are living together forever, it's not going to work, and I recommend that, for heaven's sake, tootle down to the courthouse. There's almost always at least one person in a courthouse in Virginia authorized to conduct marriage ceremonies. So do it. And if you think you've got a common law marriage, please make sure that you can document your marriage if you are in Virginia. Now, continue to unpack spouses. Did you get married overseas? We've had that case lately. We had a case where a man and a woman met each other as each of them their second spouse here in the U.S. The woman was an immigrant from Greece and had come here, was naturalized. There's no big deal about that. But they went back to Greece to get married. And I know now, because of the research we did for that case, that the American consulate in Greece puts out a booklet, 10 steps, how to make sure that your Greek wedding will be valid when you go back home to the U.S. There are 10 steps, and this couple had done 2 of them. The lawsuit was that the man, there was marital strife, and the man had fled an angry, violent wife and had come to Virginia, and he actually created a will after he got here, that omitted her. He provided for his 2 children, and then he unexpectedly dropped dead. And this Greek woman showed up and wanted her elective share. She wanted to defeat the will. And we were able to show that they were not spouses because they were not legally married in the eyes of the U.S. So, if I'm talking to you, take a hot minute to find out if you're sure you're legally married, if you got married someplace else. So anyway, back to intestate descent. Is there a spouse? Yes. Then we got the exception for children who are not the children of the surviving spouse. If there's none of those people, we look to see, did the deceased person have living parents? If yes, to one or both parents who are still alive. If no, then we ask, well, did the deceased person have siblings, brothers and sisters, or did those people have children, people who would be the decedent's nieces and nephews? If yes, to those people. If no, we start going back up the family tree and we look to grandparents. And now we're dividing probably in fourths because, right, everybody has 4 grandparents, whether they're alive or not, you had 4 of them. And so, are there living grandparents? If yes, to the grandparents. If no, did the grandparents have children besides the person who were your parents? People who would be the deceased person's aunts and uncles, or their children, the deceased person's first cousins. If yes, to those people. If no, guess what? Further up the family tree, and now we're going to great-grandparents, and we're doing the same analysis. If great-grandparents are alive, they or the survivors of them get the intestate estate. If not, we start looking sideways for whether they had other children besides the people who are grandparents. So now we're talking about great-aunts, great-uncles, or their children, second cousins to the decedent. And we keep going until we exhaust it or can't find anybody going up the family tree. If we get that far and can't find anyone, the last stop in Virginia is to consider and search for the possibility that the deceased person, when he was alive, was married to someone who passed away. All right, so different. If you're not an ex-spouse, if you're ex because you got divorced, but did the deceased person have an ex-spouse who is ex because he or she passed away and was legally married to the person we're now talking about. And we do the same analysis over there. Did that person have children from some other place? So you see we're way up at the top of the pecking order if a deceased spouse's children is who the stepkids are now. But we start looking for any other heirs, legal heirs to a predeceased spouse. And if we can't find anybody there, your estate goes to the treasurer of the state of Virginia. So if that's not what you have in mind, I certainly don't. I mean, frankly, I'm sure I probably have second cousins if we look hard enough, but I don't know who they are, and they don't know who I am. So if I am not survived by the people who are my immediate loved ones, I've chosen to have a will, and I've chosen to name charitable entities to receive my estate if there's no humans to get it. So that's how you can do things, and that's why I'm enthusiastic about really everybody ought to have a will. You might wonder, somebody dies without a will, and I've talked about this laborious search for kin. Who does that? Well, again, it's not the sheriff. I mean, the state of Virginia really doesn't do that. What would happen in Virginia is that, and maybe this is federal, stale accounts in Virginia, if an account, a bank account, a savings account, an account is stale, untouched, unchanged for 3 years, the place where that account is required to forward that account to the treasurer. And then if you owned real estate, number one, if there was a mortgage on it and you go a number of months, the lender's going to foreclose whether you're alive or not. And then they may do some hunting for who your heirs are, because if they, at the foreclosure sale, sell the house for more than what they are owed, they have to do something with the money, which is to the defaulted borrower, but now we're talking that person is dead. Then look for your kin. And if they can't find them, same thing. Money goes to the treasurer of the state of Virginia. If there's no mortgage, you still are going to have to pay property taxes. And around Tidewater, Virginia, my experience is that most of the Tidewater cities have a patience of about 3 years. So if property tax goes unpaid for 3 years, they will start the process to sell that residence at a tax sale. And then the same rules apply. If the tax sale yields more money than what is needed to pay the city's property tax, then the rest of it is supposed to go to the defaulted taxpayer. And of course, now we're talking about somebody who's dead. So they look for his kin or her kin. And if we can't find them, then that money goes to the treasurer. So it ultimately winds up in the treasurer of the state of Virginia. If you want that to not happen, you need a will. Listen, if you have questions about that, we do a lot of the work, and I'd be happy to give you a hand with that. Otherwise, I'm hoping I'll see you again next week with another topic about estate planning and estate administration in Virginia. See you then.